argument in 1 CACD 20-0350 Spector et al. The Wells Fargo. As you're aware, we are doing a video conference. This is being taped. It is not being live broadcast at this point, but it will be posted to the internet site later today. So it will be available to the public to review. Based on our current protocol, we will be arguing remotely. You each have a maximum of 20 minutes per side. I will remind you that you don't have to use all of that time, and you are required to keep track of your own time. I will do so as well. Since we're not in a courtroom, you can't see a clock, but I have a timer that I will be using, and I will try and give you signposts along the way to let you know if where you're at as far as time. In that regard, if you wish to reserve any time for rebuttal, you must do so on your own. I will advise you when you're done speaking how much time you have remaining. And if you have a question at any point as to where you are as far as time, please feel free to ask. I will be able to tell you. Please keep in mind, we have read all the briefing. We have studied the record and gone through it quite carefully, and we discussed the case in conference today. And with that then, Mr. Spector, you may proceed.
Thank you very much. Good morning to all. The facts in this case are in dispute. The appellee's attorneys will present their case as if there is no dispute. Please keep in mind that the opposing legal counsel represent only 2 of the 12 appellees. All we are asking is for a chance to submit evidence provided by the appellees through their own supplied but limited discovery and argue the facts that have not been adjudicated in court. It is impossible to comprehend that some of the foreclosure sales in Arizona have taken place without the property owners being notified. Statistically, it's likely that many of these sales have taken place without proper notice being provided. Yet the vast majority of these sales proceed unimpeded. The reason is the heavy draconian effects of Arizona Revised Statute 33811C. Fully 90% of all homeowners who receive a notice of eviction simply move out. The appellants noticed that something was wrong was this very same notice, a notice of eviction. In Patton versus First Federal Savings and Loan of Phoenix and Schaefer versus Chapman, the Arizona Supreme Court states that trustee sales statutes should be construed in favor of the borrowers and the strict compliance with such statutes. In Zubia versus Shapiro, the Arizona Supreme Court, when referring to ARS 33811C, referenced the phrase properly noticed of the trustee sale. ARS 338 person at the time of the recording, the notice of appears on the record of the county recorder in the county in which any part of the trust property is situated to have an interest in any of the trust property. A copy of the notice sent pursuant to this interest appears a record and address set forth in the document. As out, the co-appellant, Terry K. Hall, was and is on the record in the county in which the trust property is situated and does have an interest in the property by way of a recorded warranty deed dated February 26, 2007. Terry K. Hall received no notice of this sale. As stated above, statutes should be construed in favor of borrowers, and strict compliance with such statutes is required. ARS 33808E reads in part, or if there is error in the date, time, or place of sale, the trustee shall record a notice of cancellation of trustee sale. It does not read, may record a notice of cancellation of trustee sale. The trustee or any person furnishing information to the trustee shall not be subject to liability for an error or omission if the information required in section C of this section, except for the willful and intentional failure to provide such information. We are aware that the trustee sale may be postponed in Arizona with new sale dates being established at 90-day increments. When statutes contradict, such as 33808E and 33810B, shouldn't the statute which favored the borrower, as spelled out by the Arizona Supreme Court, be the one that is used? We will show that Aquin used a minimum of 4 mailing addresses for the appellants. We will also provide documentation in court that no request for an address change was ever applied. If there was no request for an address change, then it's factual. Aquin willfully and failed to provide the information necessary for us to protect ourselves and our property. We will also show through discovery provided by Aquin that at trial, that mere 20 days before the trustee's sale was finalized, Aquin provided a statement to appellants with the verbiage, "Your account has been referred to an attorney for foreclosure. The first step in the process, the first legal action, has not yet begun." From the date of the notice of trustee sale to the sale date, 900 days had elapsed without a notice of cancellation of trustee sale. Zubia versus Shapiro, the Arizona Supreme Court, referring to ARS 33-11C, referenced the phrase "properly noticed of trustee's sale." Also, Zubia, it is lack of notice is a defense that may be raised against ARS 33-11C. We did not receive proper notice of this sale. It can be proven through the discovery provided by the state of Arizona requires the borrower to comply with the strict letter of each statute with no exception provided. Should this compliance not also be required by the lender in each case? Also, will be proven in court that our only interaction, verbal and written, with any of the 12 appellees took place with Aquin. As found in the limited discovery provided, Aquin used a minimum of 4 different mailing addresses for the appellants. Aquin was aware of the foreclosure sale, deliberately failed to provide notice of or conceal the facts. The foreclosure sale must be voided, and there must be grounds for equitable relief, as stated in Steinberger versus McVeigh. In this lawsuit with Aquin, the Consumer Financial Protection Bureau found that Aquin had a raft of servicing violations, including, but not limited to, number 1, servicing loans using error-riddled information, including multiple addresses. In 2014, Aquin's head of servicing described its system as ridiculous and an absolute train wreck. Number 2, illegally foreclosed on homeowners. Over 1,000 homeowners have been wrongfully foreclosed upon. These illegal foreclosures are aided by the extensive use of global signing, where documents were signed by people who had no knowledge about whether the information contained in the documents was correct. Also, the admitted fact that Aquin routinely required borrowers to become delinquent to qualify for assistance programs such as HAMP, while having procedures almost certain to produce a foreclosure, like losing the paper pretty much all the time. Failed to credit borrowers' payments, including applying payments to wrong accounts and delivering periodic statements that were incorrect. We will show through discovery provided by please that this was the exact case. The number of payments that was misdirected is yet to be discovered. Number 4, botched escrow accounts, including sending borrowers their escrow statements late or not at all. Number 5, failed to adequately investigate and respond to borrower complaints. Its new policy requires borrowers to complain at least 5 times in 9 days before a complaint can be escalated. In our case, it took over a year for our account to move into escalation. The reason for this, we were not aware of the silent rules required to get our issues heard. Number 6, failed to provide complete and accurate loan information. The CFPB also showed that 88 borrowers for the harm it caused. The director stated that Aquin helped to properly service the loan of borrowers on every level imaginable. He also stated too often trouble began as soon as the loan was transferred to Aquin. This suit was joined by 49 states and the District of Columbia. Once again, we wish to remind the court that Aquin was the only entity that we had any dealing verbally or in form. Choice of servicer, not one the home can decide. They are a lender. Once we get past ARS 3311C, the issue of standing rears its ugly head. The question is, did option 1, standing to assign the plaintiff's deed of trust to Wells Fargo, for 5 years after option 1 was dissolved and its assets sold to American Home Mortgage Servicing. American Home Owner Servicing is pretty much the only that would have had standing. All that's option acquired by Home Mortgage Servicing. Should the the assignment of the deed of trust was signed by Letitia Arias as contract manager for Aquin, a successor in interest to Aquin Federal Bank, FSB, attorney in fact, option 1 mortgage corporation. Does the contract manager have the authority to assign the mortgage? Shouldn't it, in fact, know that one changes Sand Canyon 5 years stated in March of 2009 in a sworn affidavit, the Sand Canyon had completely exited the mortgage business and had no mortgages to assign. Again, the court is asked to believe that this trust acquired this non-performing loan and mortgage shortly before they began foreclosure proceedings, which is a direct violation of established New York State trust rules. Many mortgages and by a document mail within weeks of the foreclosure filing. It's a strong indicator that the loan documents were never obtained or were destroyed. This assignment of the trust was fabricated to create an appearance of the creditor as a real party of interest and or standing, when it is likely that the chain of title required in these matters was not performed, lost, or both. It is widely known that Wells Fargo has a manual which describes the steps necessary to obtain missing documents after the bank has initiated foreclosure proceedings. This manual provides procedures for fabricating foreclosure papers on demand. According to court papers, the manual details a procedure for processing notes without endorsements and obtaining endorsements and allegations. Those terms work proving that the companies that are proving that the company that's foreclosing has a right to kick a family out of its home. This was first discovered in the New York.
You have about 5.5 minutes left.
Thank you. This was first discovered in the New York bankruptcy case of Moda versus Wells Fargo, where the U.S. Judge Alan Groper agreed to allow the 150-page manual into evidence. There seems to be consensus that this manual sets forth the procedures in simple step-by-step fashion where magically all steps lead to corrected paperwork and, in the opinion of the court, fabrication of documents which simply never existed until a lawyer points it out to Wells Fargo that documents are lacking. If Wells Fargo is in fact fabricating documents and involves the foreclosure attorneys in the process, the ramification on the attorneys involved, it can be severe. It is also further.
Mr. Spector, Judge Brown, let's interrupt you for a minute. So, just so you understand, we're only allowed to consider arguments that you actually presented to the Superior Court. So I'd ask you to please try to focus in on the arguments that were specifically raised in the Superior Court and the reasons, the specific reasons that you have advocated for in your briefing. I feel like you're going into areas that were not presented to us in the briefing.
I apologize for that. My understanding was that I was supposed to answer questions about the summary judgment and what led to it. I can skip over a bunch of this stuff and get right to the end here. Okay?
Okay.
Your Honor, I can't hear you right now.
Go ahead.
Yeah, I cannot hear you either, Your Honor.
Can you hear me?
I can now, yes.
Go ahead and proceed.
Thank you. As expressed in the appellant's brief, it is physically impossible for option 1 to assign the deed of trust to Wells Fargo a full 5 years after shuttering its business. One cannot give what one does not possess, and that is an admitted fact. As stated in Druin versus American Home Mortgage Servicing, the assigner, as a stranger to the mortgage, could not have transferred it to the assignee. It's not an attack on the assignment itself, and thus not covered by case law holding the debtors lack standing to raise such attacks. With this being the case, the assignment of our deed of trust to Wells Fargo never took place as a matter of admitted fact. Therefore, the assignment never occurred. I'm going to go right back down here. I'm going to talk, well, that was not in, okay, I'm sorry, because we're also talking about attorney's fees, but that wasn't brought up in Superior Court either. In Newitt versus Wells Fargo, Wells argued that the plaintiffs could not challenge the judgment. Judge Arnold squarely rejected that argument, noting in the process the assignment from Sand Canyon, formerly known as Option 1, to Wells Fargo of an interest which Sand Canyon did not possess was no more effective to assign the mortgage than the lack of any assignment at all. This holds true in the current case, even more so because it was Option 1 itself that assigned the deed of trust to Wells Fargo. Option 1 had no assets on the date of the assignment and therefore could not assign anything to Wells Fargo because they had nothing to assign. If one were to observe the nationwide coordinated response to these types of cases by the lending industry from an elevated vantage point, this would look very much like a RICO case. That's it, Your Honor.
All right. Thank you. You have 5 minutes and 50 seconds remaining for rebuttal.
Thank you.
Counsel, give me just a moment to reset and start. So if you're ready, you may proceed.
May it please the court. My name is Robert Reether. I am counsel for Wells Fargo and Ocwen Loan Servicing. Can you hear me okay?
We can.
Okay. Thank you, Your Honors. There are 4 issues up on appeal. The first is whether there were any chain of title issues with respect to foreclosure under the deed of trust. The second is whether Wells Fargo satisfied notice requirements to proceed with a non-judicial foreclosure sale. The third is whether there were any statute of limitations implicated by the April 2017 sale date. And the fourth were whether the appellants were deprived of any discovery. Each of these issues has been resolved by undisputed evidence in the record before this court, and therefore we ask this court affirm summary judgment in Wells Fargo's favor. As to the first issue regarding chain of title, there is no evidence in the record put forth by appellants to support their contention that we did not have authority to foreclose in the record. Wells Fargo is indisputably the holder of the note as supported in the record, and that controls even absent an assignment. That is supported by the Vasquez case cited to in the answering brief, where the court held, quote, "The first certified question is whether the recording of an assignment of deed of trust is required prior to the filing of a notice of trustee sale under ARS 33808 when the assignee holds a promissory note payable to bearer. The answer is no. Arizona law imposes no such requirement." End quote. Thus, the possessor of the note controls as supported in the record. The appellants have failed to rebut this in their reply. But Your Honors, even if assuming possession of the note did not control, even assuming that, there is no issue with the chain of title with respect to the June 2013 assignment of the deed of trust to Wells Fargo. As to the history of the assignment, as evidenced by the SEC filings in the record, Option 1 was the beneficiary of the deed of trust. Option 1 was acquired by American Home Mortgage Servicing, who then changed their name to Homeward Residential. Later, Homeward was acquired by Ocwen. Each of these are supported in the record. Therefore, there is no issue with chain of title. Moreover, there was no requirement to record the assignment, although in this case we did record the assignment. But there is no requirement that it was to be recorded. That is supported by the Vasquez case as well as ARS 33-412. Moreover, with respect to authority to foreclose, the appellants have admitted to being in default on the loan on multiple occasions, so they're judicially estopped from arguing against that now. In the stipulation terminating the bankruptcy stay as to Wells Fargo, appellants admit to being in default. Moreover, the appellants executed a loan modification agreement with Ocwen, recognizing Ocwen was the servicer. And finally, the record reflects that appellants recognized Ocwen as the lien holder in their bankruptcy petition. These make clear that appellants have, and they don't dispute, on multiple occasions defaulted on the loan, and Wells Fargo has every right to foreclose.
So counsel,
Turning
why
to
don't you talk about the notice then?
I'm sorry, Your Honor.
Why don't you talk about notice then?
I will. I'm going to do that right now, Your Honor. As to that second issue on the respect to whether we can foreclose or whether we satisfied notice requirements, this claim has been statutorily waived by appellants because it is undisputed that appellants never sought an injunction pursuant to ARCP 65 and ARS 33-811B and C prior to the sale. That is supported by
counsel, let me ask you then, how do you expect someone to seek a preliminary injunction if they haven't received notice?
Well, Your Honor, in this case, they did receive notice, and I can get to that next. There's multiple examples of appellants admitting that they had notice of the sale, both in deposition transcript and in writing correspondence. I can get to that next if I may, Your Honor. Wells Fargo produced an affidavit of mailing that evidenced the mailing of the notice of sale to the appellants at the correct address, 2205 Edgewood Drive, Sedona, Arizona, 86336 on November 4th, 2014. There is nothing in the record to show that the appellants didn't receive it, and the Superior Court determined there was no issue of material fact concerning mailing the notice of sale, and the burden was with the appellants to provide otherwise. And even if the address was off by erroneously inserting an E for East in front of Edgewood Drive, which it was not, but the Arizona Supreme Court has rejected a strict interpretation of notice, and the parcel number and legal descriptions were correct in the notice of sale. That is supported by the Manicom case, as cited to in the answering brief, where the court held, quote, any error in the legal description of the trust property shall not invalidate a trustee's sale. If considered as a whole, the information provided is sufficient to identify the trust property being sold, end quote. And to get to your point, Your Honor, about, I'm sorry.
Notices sent on the other addresses, there was a reference to 4 different addresses being used.
I'm sorry, Your Honor, I couldn't hear very well there.
Mr. Spector referenced 4 addresses being used. Can you address that?
Yes, if you take a look at, in the record, it's IR7 at Exhibit E. That is the affidavit of mailing that shows it was mailed to the appellants at the correct address, 2205 Edgewood Drive, Sedona, Arizona. And on top of all of this, Your Honor, and perhaps most importantly, with respect to appellants, they admitted they already knew and had notice of the foreclosure sale prior to the sale and still did not seek injunctive relief, both in depositions and in writing. I would refer the court, if I may, to IR 60 at paragraph 31, which references Exhibit A, Mr. Spector's deposition transcript. At that transcript, if I may just read a quick snippet of the transcript on pages 39 and 43. On page 39, quote, question, were you aware of the February 26, 2015 trustee sale as of January 31, 2015? You would say yes, correct? Answer, yes. On page 43, quote, question. So again, in this email, you're telling us that you're aware of the February 26, 2015 trustee sale, correct? Answer, yes. End quote.
Counsel, I thought the trustee sale happened in 2017.
It did, Your Honor. That was my next point, if I can get to that.
Oh, sorry.
So again, I should also echo that once on January 31, 2015, and again on February 2nd, 2015, also Mr. Spector confirmed in writing that he knew of the pending February 26, 2015 foreclosure sale. That is Exhibit 8 to the deposition, and again on IR 41, paragraph 20, referencing Exhibit number 9. And Your Honor, to your next point, finally, as quoted, the sale was initially supposed to occur on February 26, 2015. The reason for the delay from February 2015 until April 2017 was because appellants filed twice for bankruptcy to stop the sale. In their briefing, the appellants then take issue with the overall delay from October 2014 to April 2017 for the foreclosure sale. Again, part of the delay is because the appellants filed for bankruptcy twice. And also, the delay is of no consequence because there is no requirement to send additional written continuance notices or limits on same as supported by ARS 33810B.
Counsel, is there any correlation? I guess, what was the time between the bankruptcy and the scheduled trustee sale?
Sure, Your Honor. The appellants.
The first one.
Sure. Mr. Spector filed for Chapter 13 bankruptcy on February 9th, 2015, which would have been 17 days before the initial trustee sale date of February 26, 2015. That is supported.
It's a reasonable inference that the bankruptcy was, I guess, connected to what would happen 2.5 weeks later.
Exactly, Your Honor. And then I should note that Mr. Spector filed another Chapter 11 bankruptcy on April 11th, 2016.
But let me ask you a little bit more. What did your client have to do to move the trustee sale from 2015 to 2017? What is the law required? Is it a brand new notice, or is there something less?
No, there's no need in accordance with ARS 811 or ARS 33810B. There is no need to do another full written continuance notice, Your Honor.
What do you have to do?
No other, well, I just read the statute. No other notice of the postponed, continued, or relocated sale is required except as to subsection B of 810, and there is no need to file a new notice of sale.
Okay, well, but I think your client needed to provide a notice, quote, no, this is the same statute, notice of the new date, time, and place by public declaration at the time and place last appointed for the sale?
Yes, and is my knowledge that was done just on a new notice of sale, Your Honor. And there's no notice in the record.
That's important because this case was dismissed on a dispositive motion. So is the record uncontested on the point that your client satisfied that requirement?
Yes, it is, Your Honor, and that is supported in the minute order from the court, which is IR 72. There was no issue of material fact with regards to our ability to foreclose at that point in time.
IR 72?
Correct, Your Honor.
So on your counsel, that is the posting that was done at the location as required by statute.
That is correct, Your Honor.
And let me ask you a question, because there was at least a mention of a distinction between a cancellation and a postponement. Is that any kind of legal recognition or a legal concept in Arizona, or is it simply a continuance?
It's simply a continuance, Your Honor.
All right, so there is no concept of canceling and then restarting or postponing. It's just the trustee sale is continued.
That's correct, Your Honor. And as to the third issue up on appeal, which is the statute of limitations, this was not raised below, and it's not appropriate for appeal. That is supported by the Weber-Grindle Audio Productions case, where the court held, quote, an appeal is not the appropriate place to consider issues or theories not presented below. I should note that appellants raised in their reply on page 4, they argue that this issue was raised during oral arguments at the Superior Court level. But this argument is without merit because it is appellant's duty under RCAP 11C1A to order any transcripts of Superior Court proceedings not already in the official record that the appellant deems necessary for proper consideration of the appeal. But, Your Honors, I should note that even if it was appropriately raised, appellants are mistaken in arguing that the 6-year statute of limitations expired before April of 2017 under ARS 12-548 prior to that April 2017 foreclosure sale. On this point, appellants aver in their opening brief on page 11 that they located a statement of breach and non-performance dated October 1, 2008, which claims to trigger the 6-year statute of limitations. But again, this is not part of the appellate record, and cannot be raised now. But even if it was, that document does not accelerate the loan to trigger the 6-year period because there was no affirmative act. And that act needs to be the exercise of the power of sale, which was only done by the October 30th, 2014 notice of sale, in which case we're well within the 6-year statute of limitations at the April 2017 foreclosure sale date. That is supported by the Navy Federal Credit Union case, which held, quote, a cause of action as to future non-delinquent installments does not accrue until the creditor chooses to take advantage of the clause and accelerate the balance. And finally, Your Honors, turning to the fourth issue, there is no discovery issue up on appeal. Appellants have not been deprived of discovery. This court is limited to the appellate record. Any issue on discovery should have been dealt with at the lower court level. There was never any order with which to appeal from or that appellants have attempted to appeal from regarding documents and discovery. Again, I would note that.
It's in 20 seconds, just so you know.
Thank you, Your Honor. Moreover, as appellants did mention in their page 4 of the reply, they contend that it was raised during oral arguments. But again, as stated before, it is appellant's duty under RCAP 11C1A to order those transcripts, and that was not done. The order that granted my client's motion for summary judgment made clear that discovery was not an issue, and this case can be resolved based on appellant's waiver by failing to seek an injunction prior to the sale. In conclusion, the appellants have failed to refute any of the issues in the answering brief. Therefore, we respectfully request this court affirm the Superior Court's ruling in my client's favor. And unless the court has any further questions for me, I will waive my additional time. Thank you, Your Honors.
I'm not seeing any questions. Give me just a moment, or Mr. Spector, to reset my clock, okay? You have 5 minutes and 50 seconds remaining, so I just need to reset. And then if you would go ahead from your rebuttal, sir.
Thank you. As stated in my original arguments, we only talk to Aquin. When you talk to Aquin on the phone, when you get somebody on the phone, you listen to what they say. As far as the trustee sale, we were asked about the trustee sale date in, if I'm not mistaken, in January of that year, 2015. We said we heard that there was going to be a trustee sale. We talked to somebody at Aquin. They said, we have your loan. We have no trustee sale. I said, well, what can we do to stop the trustee sale? The guy on the phone told me, all you can do is file for bankruptcy. And that's exactly what we did, because we didn't know, we had no notice of trustee sale. Nothing was posted at the house. And remember, for 2.5 years, we never got our mail, for one thing, from Aquin. And we kept calling and asking about it. Finally, I had a lady on the phone. She said to me, well, we've been sending all your mail to your P.O. box. And I said, well, I'm sorry, I don't have a P.O. box. And her exact words were, well, I've got it right here. It's P.O. Box 33372, Juneau, Alaska. I said, well, we don't live in Juneau. And she said to me, well, you could request an address change. I said, we never requested one before. There is a different address in Sedona for East Edgewood Drive. And we also got mail that was sent to a P.O. box in Emmett, Indiana. None of these things go together. 2 addresses in Sedona, 1 in Juneau, and 1 in Emmett, Indiana. As far as the deposition is concerned, they were showing me the notices of sale, and they said, "Are you aware of them?" And I said, "Yeah, I am. I'm looking at it right now." But the last time that they asked me about the notice of sale, my response was, the only thing that I can say is that we never received proper notice of sale. That was my last response when it came to were we aware of the trustee sale. We never received it from Aquin because they never sent it. I apologize for the transcript issue. I thought that when I talked to the court here in Cottonwood, or Camp Verde, I mean, I thought that ordering all the transcripts meant all the transcripts. We had 3 different judges at the Superior Court level, and all 3 judges, I brought up the issue of not having discovery, that discovery was sent to us, It was not readable. We couldn't get the download. Then they turned around and they sent us more discovery. We could not read that either. And at the deposition, the attorney at the time asked me to bring all the discs to him, and I did, brought all the discs that they had sent us to him, and they said they would provide discovery. We got another thing, I think it's called a zip drive or something like that. We managed to get some things off of it.
And
But
what I'm going to do is ask that you focus on your argument, because your reason for not having a transcript, if we don't have it, doesn't really change the fact that we don't have it.
Well, I understand that. I'm sorry again. I'm a little emotional here, as you can imagine.
Sure.
I'm sorry. I missed my my deal here. Chain of title, foreclosure. Well, that's pretty much it. We didn't. We know that there wasn't full disclosure because only 2 defendants out of 12 even answered anything. The others are not even being represented in court. So we know that they didn't disclose anything. So therefore, we didn't get all the disclosure that we asked for. That's pretty much all for me.
All right, thank you. We appreciate your time here today. We are going to take the matter under advisement, and we'll issue our ruling in due course. We apologize again for that slight delay in getting started, and thank you for your patience in doing that. And with that, we're going to go ahead and ask Lena, if you would go ahead and have Mr. Spector and counsel removed from our virtual courtroom.
Thank you, Your Honors.
Thank you for your consideration.
Thank you for your arguments.
No question. If that's not, I'll be right back to